Court decision today, with only 2 justices dissenting. A strong majority of 6 upheld the right of Michigan voters to ban race as a factor in admission to state colleges and universities. Steve Handelsman's live on Capitol Hill with more on the impact of today's decision. Hi, Steve.
Hi, Doreen. Thanks. At the High Court today here on the Hill, this was a narrow ruling. It didn't focus really at all on the issue and the subject of affirmative action, but it's reopening that controversy. In a referendum in 2006, 58% of Michigan voters approved amending the state constitution to ban any consideration of race in public college admissions and public employment. At the Supreme Court today, the 6-justice majority upheld that process. Justice Anthony Kennedy writing, "This case is not about how the debate about racial preferences should be resolved. It's about who may resolve it." The court did not rule on the constitutionality of affirmative action, but opponents are still celebrating.
Well, we live in a time with a black president, a black attorney general, when to make the kind of claims that people are being discriminated against and being prevented from entering into positions in a university or a job at a hospital or a public employment project simply no longer makes sense.
The NAACP says affirmative action is still needed.
Segregation and racial inequality exists throughout this country. In housing, we see it in employment, we see it in schools. And so that is something that must be addressed.
Justice Sonia Sotomayor agreed, saying judges ought not sit back and wish away racial inequality. And she said of the Michigan referendum, democratically approved legislation can still oppress minority groups. 8 states now ban consideration of race in admissions and hiring, and more states are now expected to ban it.